Welcome. In this video we will be talking to you about what we refer to as the estate planning matrix. For a lot of people there's a lot of jargon that is surrounding the area of law that we refer to as estate planning. What is estate planning? When you boil it down, it's really pretty simple. Estate planning is just looking to the future and saying, gee, there are some really bad things that either will happen and we don't know when or how, like death, or that may happen and we don't know when or how, like incapacity. And what we're trying to do is to plan for those catastrophic contingencies. What do we want to have done? And the what do we want to have done is categorized into two categories. What do we want to have done with our stuff, which is our estate, and what do we want to have done with our body, which is, of course, very personal. So what we've created is the estate planning matrix, which you see on the screen, to capture all these different documents that are used with all these funny names and put them in the context of that fairly simple formula. So if you look on the left-hand y-axis on this grid, you'll see the two catastrophic contingencies, death and incapacity. Along the x-axis at the top, you'll see the two consequences that we want to control or have some ability to dictate what our wishes would be after we're dead. For those who survive us, what do we want to have done? First with our stuff or our estate, and secondly with our body. I'm going to describe for you then each of these documents that are in those categories. So the documents, starting in the upper left-hand corner, we start with the last will and testament, which could or could not include a testamentary trust or replacing a last will and testament with a revocable living trust. Typically, if you do a revocable living trust, you're going to have what's referred to as a pour-over will to catch anything that doesn't actually land into the trust. In Washington state, revocable living trusts are generally not recommended except under certain circumstances. But as you can see, the last will and testament is what happens to your stuff after you die, and you're putting that into a writing with formalities that must be followed, or else that writing won't be honored by the court after your death. Along with that, the second item down is the personal property disposition list, and in parentheses you'll see RCW 11.12.260. RCW stands for Revised Code of Washington. In other words, it's the statutes that govern Washington state residents, or the law in Washington. And that's the law that governs this personal property disposition. Well, what is it? It's actually something that says you can dictate what happens with personal property, not real property, but personal property, without having to go through the formalities of two witnesses and a notary like you do with the last will and testament. So it typically is the tail on the dog. The dog is the last will and testament, and the personal property disposition list is the tail. And we split it out because it is therefore more convenient for you to say, well, I want my guitar to go to my old college roommate Sam because he taught me how to play. And you can do that and change it as you wish. Moving down the segment of death and stuff, we have the community property agreement governed by RCW 26.16.030. That's for spouses who are saying we want to have all of our property that we own now to be deemed or characterized as community property, and all of the property that we acquire to become community property when we acquire it, however we acquire it. And when the first of us dies, we want all of the community property to pass to the surviving spouse. That's referred to as a three-prong community property agreement, and it avoids probate for the first of the spouses to die. Not for the second, but for the first. The next item is a contract to limit surviving spouse's disposition. This one is where you have a married couple and one spouse dies, the other spouse is surviving, and they have children, but the surviving spouse then gets involved with, we'll use a colorful, perhaps pejorative name, Mrs. Gold Digger. And so the surviving spouse marries Mrs. Gold Digger, who then he says, okay, well, I'll give all the money that I have when I die to Mrs. Gold Digger, and the children don't have any. This contract to limit surviving spouse's disposition is one way to solve that problem. And then finally, in that section of the matrix, we have the letter of last instructions, or what we refer to as the PR, Personal Representative's Manual. In other words, whoever is going to be the person that's going to be most responsible for your affairs when you die, you want to give them a letter that says, here's where you're going to find all the critical documents, and here are the people that have helped me, attorney, accountant, etc., that can help you to inventory the estate and then make sure that everybody gets what they're supposed to get. So that's dealing with the upper left-hand quadrant of the estate planning matrix. Let's move on down. Well, actually, let's move to the right and go to the what happens to my body when I die. A lot of these documents are controlled by statute, but not necessarily, they don't necessarily require the same level of formality that a last will and testament does. Some of them don't have any formality, and you can just do what you want, like the letter of last instructions. There's no statute for that. That's just practical good sense. When we get to the upper right-hand quadrant of the matrix, what happens to our body when we die, we can leave memorial instructions. We can leave organ donation forms so that you could have your organs harvested from your body and used by other people who are in need, who are still alive. And you can have a do not resuscitate form, which would be only for those people who are so close to death that they say, no, I don't, if I'm going to go, let me go, don't try to bring me back. Very rare circumstance, but it's on the list to see if, somebody says, yeah, that's something I want. And then probably the most important is the final arrangements form, RCW 68.50.160, subsection 1. That does have some level of formality. You do need to have some witnesses, but it is a statement to say, I want to have my body cremated, or I want to be buried, or I want to have human composting, which is now available in Washington State. Finally, in the upper right-hand quadrant, we have the death with dignity planning, and this is in Washington State. Washington is one of, I think, only 2 or 3 states in the Union that do allow people who are definitely going to die the ability to work with their doctors ahead of time to say, go ahead and inject me with medicine that will take me out painlessly and quickly, rather than going through a prolonged illness that is financially costly and is also painful. But the main reason that's on the list is you need to do that well ahead of the time. You can't just at the last minute say, oh, I'm in too much pain, help me go faster. You got to do that with some planning. Let's move to the lower left-hand quadrant. Now we're dealing with what happens if you become incapacitated. And of course, incapacity can happen suddenly like a car accident, or it can happen slowly like Alzheimer's or Parkinson's. It can be mental incapacity with a mental illness, or it can be physical incapacity, or both. And so there's a lot of sort of sub-contingencies within that main contingency of incapacity. In the lower left-hand quadrant, we start with the springing general durable power of attorney, governed now by RCW 11.125, which is the new Uniform Power of Attorney Act, passed just a couple of years ago here in Washington State. It amended some of the old provisions, but most of them are the same. In any event, what does springing mean, and what's a general, and what's durable, what's a power of attorney? Each of those terms requires some explanation. Power of attorney actually refers to the document itself, and it's saying, I, as the principal, the person that's signing this, am going to say that person B, my agent or my attorney in fact, who will hold my power of attorney, the document, can have the power to do things that I can do now. And so that's the power of attorney. Your durable power of attorney is one that will endure, is not time limited. And that's what most people do, is they say, well, if I'm going to hand off that power, I want to have it so that somebody can take it and run with it for however long it needs to happen. General is opposed to special. So a general is just pretty much anything I can do, you can do better, or you can do too. That's a general, as opposed to a special, which would be limited in the scope. You can handle my real estate transactions, but you cannot run my business, for example. And then finally, springing simply means, and this is the typical power of attorney that we do in estate planning, it will only become effective once and if, when and if you become incapacitated, and will endure even after your incapacity. If you don't specify that it's going to endure or be durable, it will legally disappear in terms of its effectiveness without a paragraph on durability. Let's go down to the next item, the next checkbox, and that's with guardian nomination for self, and then another checkbox for and orphaned children. And here we've got a couple of statutory citations, RCW 1188.080 and 11.125.410. Well, a guardian is basically saying, hey, if I'm a parent and I have children that are left behind, I want to say who's going to be the parent for those children. Now, note when it says orphaned children, it is only because if one parent of two parents dies, the surviving parent will have the right to raise the children. If it is the surviving parent that dies and there is no parent remaining who has legal ability to raise or legal authority to raise those children, then the nomination of the guardian becomes important, because that's who the court would most likely nominate, unless they're an axe murderer or an abuser, and then the court can say no. Typically also, if you have a status of incapacity and you need a guardian for yourself because of your own incapacity, you can nominate who that person would be, and again, the court must follow your wishes unless there's good reasons not to. Finally, the bullet point in the lower left-hand quadrant is personal fact sheet. This is simply an inventory of your estate, so that if you reach death or incapacity, you have sort of an inventory or status of what you own and owe at that point in time, and it's helpful for your survivors to pick up the baton and run with it. Let's move to the lower right-hand quadrant, and we're talking now about incapacity and what happens with your body. Here we have a healthcare power of attorney with a HIPAA clause, and that's RCW 11.125. The power of attorney statute is the source for this. Same thing, power of attorney, but now we're dealing with healthcare decisions, not what happens with money. And you can put those in the same document, but we split them out into two different documents because we want to emphasize to people that you can have a different agent to deal with your healthcare decisions than you do with your financial decisions. You can do the same person, but you can also do different. Moving down in the lower right-hand quadrant, healthcare directive, also known as a living will. It's based on RCW 70.122.030. This is a statutory form. Now, there are other forms available on the internet and by various organizations that are more comprehensive than what the legislature wrote in the statute. But the basic form for a healthcare directive is you're about to die, you know you're going to die, and you're just saying withhold water, withhold nutrition, but give me the pain medication that I need so that I can pass without pain, which is how most people on the planet have passed, is that they've starved to death in the last and final stages. Then we move to the mental health advance directive. This is a special type of actually power of attorney and advance directive. It actually has more influence as a power of attorney, but the statute called it a mental health advance directive. What is it? It's for the mental illnesses that cycle. Bipolar would be probably the classic, where you have periods of manic episodes and then periods of depressive episodes, but in between you've got people that are functional. And so while they are functional, they retain their own authority. When there are certain conditions met, then the power of attorney kicks in and the agent takes over, so that the person doesn't do things that are harmful during periods of mental illness. Finally, at the bottom, we have LTC and LTCP Medicaid. Basically what we're talking about, LTC stands for long-term care. Long-term care is mostly covered by Medicaid, which is a federal program, but it's administered by the state, so there are differences between each state on how they do it. So you want to make sure that you're looking at that. And that the reason that's on there is nursing home care in Washington State now averages about $10,000 a month. So if you need it, and 70% of people who are age 65 or older statistically will spend some time in a nursing home facility, and the average is, fairly short, but there's quite a few people, a significant minority, that spend 2 or 3 years, and some even longer, like 5 years. And so you want to plan for that, and Medicaid can pick that up, but you can be eligible for Medicaid only if you manage your finances in a certain way, and we can help you to navigate those rules. Finally, the last bullet point is POLST. POLST stands for Physician Order on Life-Sustaining Treatment. This is a form put out by the American Medical Association. Here in Washington, it's put out by the Washington Medical Association, typically on a green sheet, and it would be in your hospital record. This is going to cover some of the same things that we have in this estate planning matrix. So you just want to make sure that if you have a POLST on record, that you replace it with whatever your documents are that you're preparing with us. And that gets us through the estate planning matrix. We just want to show you very quickly that we also have an estate planning process that we go through, and this is just the initial appointment where we'll describe these things, pick out which documents you want, and then we get you a questionnaire that you fill out, an estate planning questionnaire, which helps to do the inventory. Then we'll draft the first draft, send it to you. You review the first draft, you make corrections, changes, and additions, and then note any questions, return that draft. The attorney drafts the final draft, schedules the client for a review session if necessary, and then also the execution or signing meeting. And so usually we don't need to do a review session. Usually we can do it over the phone or in screen share and cover all the things that you have questions about. And then we'll do the final executing of the document or documents, and that'll be before a notary public and 2 witnesses for the most formalized, the last will and testament, and otherwise as necessary for each of the documents. And we'll give you some final instructions. So that's it. That's the estate planning matrix and the estate planning process. Thank you.